Writing strong business contracts is key to ensuring they're enforceable and reflect your intentions. A poorly written contract can lead to confusion, disputes, and expensive litigation. On the other hand, a clear, well-drafted agreement can prevent misunderstandings and strengthen business relationships. Whether you're hiring a contractor, entering a joint venture, or providing goods or services, here are some key tips for writing strong, enforceable business contracts in Oklahoma. Verbal agreements may be enforceable in some cases, but they're much harder to prove if a dispute arises. Always get your agreements in writing, even for seemingly minor deals. A written contract ensures that both parties understand their rights and responsibilities and gives you something solid to rely on in court if needed. Avoid vague or overly complicated language and be as specific and detailed as possible. Define each party's duties, list deadlines and payment terms. Describe deliverables or services in plain language. Include how parties will handle disputes. Ambiguities in contracts are typically interpreted against the party that drafted them, making clarity crucial. Ensure that each party is clearly identified by their legal name rather than a nickname or trade name. If the other party is an LLC or corporation, confirm the correct entity name by checking with the Oklahoma Secretary of State's office. Also include contact information and, where applicable, the name and title of the person signing on behalf of a business. A strong contract in Oklahoma should include several core provisions, such as payment terms, how much, when, and how payment will be made. Termination clause, how either party can end the agreement, default, and remedies. What happens if one party doesn't fulfill their obligations? Governing law, specify that Oklahoma law will apply. Dispute resolution. Consider requiring mediation, arbitration, or jurisdiction in your county. If the contract involves intellectual property, confidentiality, or non-compete terms, ensure that it includes tailored clauses addressing these issues. Your contract should clearly outline the process for making changes. A simple clause stating, "Any modification to this agreement must be in writing and signed by both parties," can prevent later claims that verbal changes were agreed to. A contract is not enforceable unless both parties sign it. Ensure that the parties sign and date all copies and retain copies for your records. Before signing an important business contract, especially one involving large sums or long-term commitments, it's wise to have a qualified Oklahoma business attorney review it. An attorney can identify hidden risks and clarify obligations, as well as help you avoid future legal trouble.